So we're now live for the hearings into the Principles of the Treaty of Waitangi Bill. I welcome everyone. Our submission this morning is from Darryn Aitchison on behalf of YouthLaw Aotearoa. Darryn's joining us online. And so just before I start with Darryn, I'll just seek leave of the committee for Te Pāti Māori staff to take pictures and video throughout the hearings. So that's fine with that.
Benson gets on it. Will Labour be front?
I'll just take that as leave thought. I'll do that also for I'll do a general leave request for all parties staff, so we don't do it throughout the day. But if anyone else in the public will just reiterate no photos or video from them. Okay, so Darryn, thank you for that. Thank you for being with us. Welcome to the Justice Committee. We've got you for 10 minutes this morning, so I'll hand over to you to begin your presentation.
Got it, Kaio. Thank you very much. Can you hear me okay? Excellent. So yeah, you'll see from our submission that there really are two main objections to the bill. The first objection relates to the bill's connection to the legal needs of rangatahi Māori. Our job as a community law centre is to reduce legal harm in the community and reduce the number of legal issues and target resources as efficiently as possible. Being young and being Māori is one of the key indicators of legal harm in the community, and young Māori make up 63% of the most vulnerable group of young people in the community who will experience high legal needs. The types of issues that they face are connected to socio-economic disadvantage, which is itself connected to the impact of colonisation. And the legal issues that young Māori face include such things as unlawful exclusion from school, barriers to housing, and barriers to accessing social security. So pretty fundamental rights and benefits that young people should be able to access. Now, we believe this bill will reduce access to justice for young Māori, essentially by limiting the jurisdiction of the court to consider the impact of colonisation and te tiriti breaches, etc. So that's our first objection. The second objection really goes to the constitutional nature, I guess, of te tiriti o Waitangi. In my lifetime, the relationship between Māori and the Crown has changed immensely. Tangata whenua have and continue to make great strides in throwing off the burden of colonisation. And while there is a long way to go, in my reckoning, the future for tangata whenua appears extremely bright, and this is something that we should be celebrating. We're not surprised that this bill, I guess, has come up. It's really, we're not surprised by the pushback, I guess, to the advances that tangata whenua has made. But we think it's a fundamental breach of the treaty and a really simplistic response to what is a really complex problem, which is the relationship between tangata whenua and the Crown in a constitutional and liberal democracy. Our view is that young people deserve better from our parliamentarians than what they've got through this bill, and the fact that it's even made it to this stage of the House processes. Young people deserve a proper conversation about the place of te tiriti o Waitangi in our democracy. We've heard the word race used in relation to these issues. We think young people do deserve a conversation about race in Aotearoa, but it needs to be one that faces with courage and honesty the impact of colonisation on Indigenous communities. And this bill is not a conversation about the place of te tiriti in our community, in our constitution, and it's not an honest conversation about race and other issues around colonisation. We understand it's complex working te tiriti into our constitution. It raises issues about sovereignty of parliament. We have heard in the commentary about this that it is uncertain, not knowing what the treaty means and how it fits. But that's what relationships are like. And young people deserve a government who will lead a conversation about these things and continue the work of its predecessors, which were those who convened the 2011 Constitutional Advisory Panel. That's the sort of process which should be used to look at constitutional change and to look at how te tiriti fits within our constitution. We've seen a lot of confusion and scaremongering about te tiriti and how it fits, but this is not a novel concept, and we see businesses, sports team boards, families, those are all examples within the community where power is shared, there's co-governance happening, there's complex governance arrangements at play, and we make it work. Our view is that we just haven't been very good at actually explaining what's going on in relation to te tiriti or waitangi and bringing people along on that journey. I think we need a different metaphor. We're all familiar with the nuclear family, where two parents work together for the best interests of their children and every child flourishes. That is a metaphor I think that could work for our conversations about te tiriti and how it fits within our constitution. Our view is that this bill is not an attempt by Parliament to address these complex issues. Why? It can't be an honest attempt because the ACT Party has essentially agreed to peace in the coalition agreement, knowing that it wouldn't get past the first reading. So it can't be an honest attempt to really address these issues. We think it's simple politics at play, and it's not appropriate when dealing with complex constitutional issues like this. Our view is that as parliamentarians and as select committee members, your job's to go back to the executive and the party whips and tell them that we want something better. And that's what we think young people are entitled to. Kia ora koutou. It's our submissions.
Kia ora, Darryn, and thank you for the work that you do for our young people in New Zealand. I'll start with the first question from Takata first, then Todd, and then Tim.
Tēnā koe, Darryn, ngā mihi o te ata ki a koe me o mahi. My experience in the House in a year that's gone is that there's a significant knowledge gap when it comes to dealing with the treaty in the House. I hear the complexity that you're speaking about, and ultimately you're driving us towards the impact, intended or unintended, on rangatahi. We sort of advocate that MPs should have to have a prerequisite level of knowledge about the treaty and the history before being allowed to come in. And so to get to a place that you're speaking about, a place where the debate on te tiriti or waitangi is more helpful and quality, what do you think Parliament might do in terms of its structure and how it operates to improve that?
I think, yeah, it's a really interesting question. I think that, I mean, there's certain things that any workplace should be doing. I think given our constitution at the moment, you don't need that knowledge to become an MP, but certainly, you know, your job as an MP primarily as a parliamentarian is to write good laws. And so I think parliamentarians need the tools to write good laws. I'm a lawyer. I've worked in the front line of community law centres for 20 years. We see day in, day out the impact of bad laws. So I think there's definitely, I mean, I think that at the very least, you know, there's an answer to your question, which is quite narrow in scope, which is the job, you know, it's essentially employment kind of issue. But in terms of the constitutional issues, like, I think that this is a conversation that we need to have. I'm Pakeha. I am scratching the surface in my knowledge of te tiriti and how it fits within Māoridom. It's not for me to say, I think, what sort of training is required. I think that's a conversation we need to have together and come up with the answers to your question collectively. I think that's the promise that we made when we formed the partnership that we did 100 and however many years ago it is.
Thanks, Darryn. We'll go to Todd Stevenson and then Tamitha.
Thank you, Darryn, and thank you for making your submission. In your remarks, you mentioned that the treaty leads us to complex governance arrangements and co-governance. I'm paraphrasing, but you mentioned those things.
Yeah.
So is it your submission then that the treaty does deliver different rights based on ancestry?
No, not at all.
Okay.
Thank you.
Thank you. Tamitha Paul.
Kia ora, Darryn. Nice to see you again, everyone. I saw Darryn yesterday submitting on the boot camp bill, another bad one, another bad law. What do you mean in plain language when you say in your submission, increase the probability that rangatahi Māori will experience increased legal harm? Can you just explain to the people what you mean by legal harm?
It's quite complex, but yeah, lack of accountability is an issue for young people. So young people are very unlikely to make complaints in a legal context. So for example, if they are unlawfully excluded from school, they just don't challenge those decisions. And what that means is that essentially that the unlawfulness, the structures around how young people access justice leads to harm, as do bad laws themselves.
Nice,
So
thanks.
make sense? Yeah.
No, thank you, Darryn, and perfect timing. Thank you for your submissions.
Thank you for the opportunity.
Spending the other time with us. We're going to move to our submission now from Te Hunga Roia Māori or Aotearoa. And I think we have Ty. Welcome, Ty. Morning. You've got 10 minutes with us this morning, so I'll hand over to you to start your presentation.
Tuatahi tēnei rā te mihi atu ki a koutou, te kōmiti e whiriwhiri nei, tēnei take I tēnei wā. Good morning to the committee. My name is Tai Ahu. I am from Waikato Tainui in Ngāti Kahu. I'm currently a lawyer that works for a small law firm called Fire Legal on a range of Māori legal issues, including te tiriti. I'm here this morning presenting in my capacity as the co-president of Te Hunga Roia Māori wa Aotearoa, the Māori Law Society. My friend Natalie Coates presented to the committee on Monday. In her personal capacity, she is the co-president Tumuaki Wahine of Te Hunga Roia Māori wa Aotearoa. And as you might expect, we support and endorse the submissions made by Natalie in her submission. We also support the submissions made by the New Zealand Law Society in their written submission. So a little bit about who we are. The Māori Law Society was established in 1988 and represents the Māori legal community, including Māori lawyers and students from around the motu. We all stand united in opposition to this bill and ask the committee to recommend that it does not proceed into law. I would like to make a preliminary point about the process, because the assurances of the Prime Minister, most recently at Ratana, that the bill will not proceed into law, are cold comfort to Māori, whose historical experience of the law has been one of land confiscation, of denigration of culture and language, and the denial of Indigenous and tiriti rights. Those assurances also ignore the divisive impact that the bill has had so far, even though it is of course not yet law. In many ways, the damage is being done right now as we speak. The bill has already exacerbated institutional distrust by Māori towards the machinery of government. It has already fostered cynicism in our political system and in the lawmaking process. And most importantly for Te Hunga Roia Māori, it's already caused many Māori to become sceptical of the law itself, a law that for the past 50 years or so has strived to come up with a way to try to restore, recognise and protect tiriti rights, not take them away. I think it is important, firstly, for the committee to ask itself, what will the practical effect of the bill be? In Te Hunga Roia Māori's submission, whānau need to know that the effect of this bill is not just theoretical. The full reach of the bill is impossible to tell at this point in time, but it will have real-world consequences. I don't think that it will override long-standing case law that recognises te tiriti as an aid to statutory interpretation, such as the Huakina case, Barton Prescott, Trans-Tasman Resource Limited and Taranaki Whanganui Conservation Board, to name a few of those cases. The treaty will still be legally relevant where it is referred to in statutes, but the problem is the bill will strip te tiriti of much of its substantive content and its legal meaning. In particular, the recognition that iwi hold and exercise te tino rangatiratanga. The practical legal effect of the bill, for example, will change how the law recognises and provides for Māori cultural values, how decisions potentially are made about the placement of Māori tamariki in care, how decisions about resource consent applications for things like discharges of effluent near Urupa and in rivers and streams will likely change, as well as decisions, for example, about the recognition of Māori language and culture and education. All of those are potential areas that the bill will impact on. And I would suggest to the committee that the legal impact of the bill across the statute books as a whole has not been carefully or thoroughly thought through in the drafting. We think it's important to be upfront about the intent behind this bill. It has been cunningly but explicitly designed to strip away many of the pre-existing rights of Māori as Indigenous people. This is evident when we read how the principles in practice operate. As you know, Principle 1 gives the Crown the full power to govern and the full power to make laws in the best interests of everyone in accordance with the rule of law. And there are two important issues in relation to Principle 1. Firstly, it doesn't attempt to reconcile or address several Waitangi Tribunal findings that Māori never ceded sovereignty in a total sense. Also, Principle 1 fails to recognise that since 1840, the Crown's power has never been unbridled. Cases as early as 1847 in Aaron Simmons through to the 2003 Lands case and beyond have recognised that the Crown's right to govern is constrained by its pre-existing duties it owes to others. That includes Te Tiriti o Waitangi and Tikanga Māori. This is not controversial. It is a fundamental part of how Crown exercise power in our country, and it is the orthodox legal position. There is no good reason to have a law that cherry picks or confuses that long-standing basic proposition. Secondly, Principle 1 assumes that recognising distinct pre-existing treaty rights somehow detracts from the rule of law, somehow takes away from the idea that we are all equal before the law. This differentiation is false. Our law has always sought to accommodate differences for different groups of people where those differences are justified and recognised in the law. There is no such thing as some colourblind utopia in our law. Principle 2 of the bill relegates Māori rights and interests to those negotiated in treaty settlements where those differ from the rights of the ordinary citizenry. It strips out the recognition of tino rangatiratanga, and as other submitters have stated, treaty settlements have never reflected the totality of Māori rights and interests under the treaty. They were never negotiated in that context, and this principle uses historic treaty settlements in a way that was never intended, to confine, limit and codify the current and future application of te tiriti. Principle 3, that all New Zealanders are equal before the law and that everyone has the same fundamental rights. Now, that principle ignores many parts of Māori society who face barriers to equality which others do not. And many of those barriers were actually of the Crown's making, which means that Māori do not always have a level playing field when we're talking about other New Zealanders. Equitable treatment, we think, is required to ensure that those outcomes can be more substantively equal. Now, the final point I want to make before opening up for questions is that Te Hungaroa Māori is not opposed to a national conversation about te tiriti, but our point is that forcing Māori to participate defensively in a constrained select committee process and under the threatening shadow of a bill that strikes at the heart of the treaty is not a national conversation. It is very damaging to the relationship between Māori and the Crown, and we need to do better. Nō reire aku rangatira tēnei te mihi kia koutou, tēnā koutou katoa.
Well done.
I've got two questions lined up, first from Duncan Webb and then from Tamara Paul, and then Rawari, you've got time.
Kia ora, I'll be quick. Look, I want to ask you a big picture question, and that's in terms of the treaty's impact. To what extent do you think, the treaty and the partnership it creates is important to ensure that Te Ao Māori tikanga and customary law is actually taken into account by our courts and our parliament when we approach kind of law making and law doing?
Well, I would say that the treaty has been a really important linchpin for the Crown. It legitimises the exercise of that Crown power. That's the first point I'd make. But it has been an important pathway to ensure that things like Māori health, Māori language, Māori culture are included and factored into the lawmaking process and as part of our law. As I said, I don't think that this will render the treaty irrelevant, but it has a very powerful chilling effect in the development of policy and it has substantive legal effect that strips away from that original intent.
Thank you, Tai. Tamitha, and then Rowley, if we've got time.
Morena, one of the big comments that people in support of this bill have been making is around the judiciary, and they've been saying that you know, the unelected judges is the main thing that a lot of them have been saying. Could you speak to the judiciary, how important it is, that separation of powers, and talk to us and talk to the public about why that's so critical?
Absolutely. I think the judiciary, many of whom have really taken an unfair rap, and certainly in the past 5 years or so, where I think a lot of criticism has been unjustified. They are an important branch of the government. They are there to ensure that there is a balance of power across the whole exercise of government. So I think that we have to be able to trust the judiciary and to be able to ensure that they are considering the case before them in light of the law that exists currently. Most of the cases, I think, are actually being relatively orthodox application of treaty principles, and not in a way that's been inconsistent with our kind of liberal democracy. Yeah. So I think a lot of the criticism has been unfair.
Sure, Tai. Thank you. That's all the time I've got this morning. So I just want to send my appreciation for you being with us. I move to a submission online from Ananish Chaudhuri.
Kia ora, Morena.
We've got you for 10 minutes this morning, so I'll hand over to you for your presentation.
Thank you. Kia ora, Morena, tēnā koutou, tēnā koutou, tēnā koutou katoa. My name is Ananish Chaudhuri. I'm Professor of Economics at the University of Auckland. My views are my own and not those of my employer. Thank you very much for giving me this opportunity to speak this morning. By way of background, I was born in India and did my undergraduate studies there. I studied further and then taught in the United States for many years. I'm a citizen of New Zealand and I've called this place home for more than 2 decades. I have 2 daughters, 19 and 16, who were born here. I support the treaty principles bill introduced by ACT. I believe the debate around this bill is fundamentally important if New Zealand is to remain a multi-ethnic and multicultural nation. I acknowledge the discrepancies between the Maori and English versions of Te Tiriti Waitangi. But I believe that the debate on whether Maori ceded sovereignty to the British Crown is sublimated by a long list of subsequent acts and laws that hold New Zealand to be an independent sovereign state. Parliamentary sovereignty has long been considered a foundational constitutional rule. I may be wrong. But to those espousing the Maori did not cede sovereignty view, I wish to highlight 2 issues. First, is it really possible to have separate laws, separate schools, or separate health systems for one ethnicity? It does not work. I think a lot of people are of the view, what is wrong with the status quo? Why rock the boat? But the problem is that the demands for separate treatment tend to expand and encompass more and more areas of social interaction. A liberal democracy cannot survive unless everyone is treated equally, subject to the same laws. I have just returned home from an extended visit to India, the country where I was born. I actually got back yesterday. I'm seriously jet lagged because it's 1 a.m. for me right now. But I felt compelled to speak here today. This is especially because if you want to see the pernicious effects of different policies for different groups, then India's experience provides a cautionary tale. India has one rule for one set of religions and another for other religions. Some states are treated differently from others. There are extensive reservations in education and jobs based on ethnicity. The result is outright hostility between groups. This often prevents mutually beneficial exchanges between them. It has led to the demise of parties with broad national appeal and seen the rise of numerous small issue-based political parties that cater to the demands of specific interest groups. There are other examples in other countries. In all such cases, these divisions are seriously detrimental to social and economic progress. I'm afraid that we in New Zealand may be headed down this path of ethnic tension and hostility. The second issue I wish to highlight is this. According to the 2023 census, as much as a quarter of our population identify as neither Pakeha nor Maori. The 1987 Court of Appeals decision essentially envisioned the treaty as a partnership between Maori and Pakeha, or the Crown. But if you accept this bicultural view of New Zealand's citizenship, that the treaty indeed establishes a partnership between two out of many ethnic groups residing in the country, then what does this imply for the quarter of the population that is neither Pakeha nor Maori? What loyalty or kinship can this quarter of the population, full-fledged Kiwis like my daughters, feel to a country where their very existence seems to be an afterthought? Are they destined to be second-tier citizens governed by an uneasy alliance between the Pakeha and the Maori? If the basic argument is about equity, then why are these people being excluded? Why race? Why not need? We have a choice. We can choose to remain a liberal democracy where everyone counts, or we can become an ethnocentric nation based on identity politics and driven by ethnic tensions. Because make no mistake, the current path where particular ethnicities are granted partnership status can only lead to the eventual appearance of more ethnic parties fighting it out for a seat at the table, as has happened in other parts of the world. Thank you very much. I'm going to stop here. I'm happy to answer questions if there's time.
Thank you, Ananish. We've got 3 questions to start. Todd Stevenson, then Tampa Paul, then Takatapiris.
Thank you, Anash, for your submission. And I think you represent the view of many who would like to have this conversation. In fact, even some of the people who are submitting against this bill have said it's time we have this conversation. What is the effect, and obviously you're an immigrant and come from an immigrant community, what do you think the effect is if we don't actually get some definition around what the treaty means in modern New Zealand for our society and as you said, the rights for everyone?
Well, obviously, that's a broad question, and I don't know the exact answer, but it seems to me that there is no other option other than to have a liberal democracy where the same rules apply to everyone. Because if we go down this path of different rules for different people, there is really no ending to it. Because people are people. Once we get used to these separate rights, separate rules, it is very difficult to give up on those or to change track and go back. So the current process, the current process to me really completely ignores this quarter of the population that has been here for a very long time, that are citizens, but don't seem to have a seat at the table.
So Ananish will go to Tampa Paul, then Takatapiris.
Morena Ananish. So you talked about your first point was about separate schools and separate systems, and I understand the point that you're making. So why is it okay to not have schools based on, what you're talking about, but it is all good to have charter schools, which separates people who can afford to send their kids to charter schools and people who cannot send their kids to charter schools? What's the difference between the current status quo, where we have 2 different types of schools for different economic classes of people? Why is that okay? And then schools like Kura Kaupapa and mainstream schools is not okay?
But I did not say that. I have not addressed this issue of charter schools versus regular schools.
You
I'm
did, you
simply
said
saying-
separate schools.
Sorry.
I understand, but I'm simply talking about schools based on separate ethnicities. Again, it's
Yeah, what's the difference between
Oh, no, no.
ethnicity and class?
there
Why
is
is,
a- there is
why
a-
is one
there is a-
okay and not the other?
Samantha, we're going to take.
there is a very fundamental
Anish.
difference. Sorry.
What we're going to do is I'll just pause your time for a second, so that we can conduct the hearings with a relative amount of order and time, people can get their questions. SUPs will have to come through the chair because we do have people lining up for questions, and if we have members yelling out SUPs constantly and engaging with the submitter, it uses up other people's time. So I'll let you finish, Ananish, and then we're going to go to Tākata Ferris.
So, oh,
First.
Yeah, we'll move on to the next question from Tākata.
Kia ora, Ananish. I just want to put into our discussion a little bit of clarity that multicultural New Zealand began in 1840 because it wasn't the British who got entry. It was the British, the French, the Austrians, the Germans, the US. They all came in at the same time. So the multicultural idea is a long dispelled idea. So my question to you, Ananish, is this. Do you have an Indian passport and do you have a New Zealand passport? And if you do have both, would you give up the Indian passport for the New Zealand passport?
I have given up my Indian passport for a New Zealand passport.
Ka pai, kia ora.
Okay, thank you. If there's probably time for one very quick question. If anyone has any? No, okay, we'll wind up there. Thank you, Ananish, for your time this morning and for presenting to the committee. We do appreciate you being with us at this early hour.
Thank you very much. Thank you for having me.
We've now got a submission from Lorraine Toki. Lorraine is joining us online.
Oh, sorry. Oh, nice.
Kia ora, Lorraine. Welcome to the committee this morning. We have you for 10 minutes for your presentation, so I'll invite you to start your presentation.
Kia ora koutou. Ko Lorraine Toki ahau, he hui ahau no Ngā Puhi. My name is Lorraine Toki and I whakapapa to Ngā Puhi. I'd like my submission taken as read. Just on ceding sovereignty, Ngā Puhi did not cede sovereignty to the Crown when our tupuna signed Te Tiriti o Waitangi. The treaty, the Waitangi Tribunal report from the Stage 1 Te Paparahi o Te Raki hearings confirms what Ngā Puhi already knew. We did not cede sovereignty. Now, my oral submission is mostly around historical things that are repeating themselves today, touch briefly on equity, settlement negotiations, and our mokopuna. Patuane said, "It is only in the time of my great-great-grandchildren that the dreams I have for my people will start to come to fruition. Now you chase me away. In the time of my great-great-grandchildren, you will come looking for me." Now that was referenced in Waitangi 2024 by two of Patuane's descendants. I want to talk about the process. The process has not engaged Ngā Puhi whānau and hapu. There has been no engagement. And if there has, I'd be interested in who with. The proposed bill itself seeks to destroy the very fabric of our whānau. And this government has a responsibility to strengthen Aotearoa, not knowingly have a coalition agreement that is destroying the very fabric of our whānau, of our communities. The bill alters the recognition of whānau and hapu in the name of equality, of all things being equal. So the bill infers that we are all born equal, and we're not. We're not born equal. There's no equality in a society that alienates people from their whenua, from their reo, from their mātauranga, their taiao. We lost thousands of acres through private and government purchases, policies that had nothing to do with equity and equality, more to do with greed, I would suggest. And history today is repeating itself. Only this time it isn't our whenua. We haven't got a lot left. It is us. We are being traded. After the signing of Te Tiriti o Waitangi, settlers and companies representing them attempted to purchase land without consulting with Maori, and it is still going on. The behaviour is repeating itself today, attempting to change the very fabric of our whānau without consulting although today we prefer the word engaging. There is nothing in this bill that will improve our economy. I don't see where whānau will benefit economically because the right to make decisions with our supposed partner will not exist, and it barely exists now. How our whenua is used, how our taonga might be or are exploited, these things are eroded for the sake of a coalition agreement. The kōrero floating around by MPs, our Prime Minister, Deputy Prime Minister in particular, is that this bill will not go any further. Why are we wasting our time responding? Well, the ACT leader would likely provide a narrative that the lack of response is a sign of acceptance. I don't want to open that window of opportunity. I would never have bothered. This process has brought a lot of us together, yes, Māori and non-Māori, but it has also enabled to create a hostile environment with misinformation being peddled by ACT and supporters of like-minded people. Perhaps the correct question to ask is, why did this government let the bill get to this stage anyway? The social wellbeing economy is built on the misery of Māori, poor health stats, high prison numbers, low education outcomes. That in itself, if there was true intent to devolve, perhaps these stats might be a little bit different, significantly different. Settlement negotiations. Ngāpuhi whānau and hapu will be further alienated because the proposed bill only recognises, as I understand it, those who have settled, and that concerns us. The initial draft of the proposed bill was broad on this issue and has since been amended, as I understand it, to be more specific when it comes to the rights of hapu and iwi who have settled. The amended wording, and I stand to be corrected, to provide that the rights of hapu iwi differ from the rights of everyone else only when those rights are agreed to as part of a treaty settlement. An afterthought, I suggest, and I wonder how many more afterthoughts there will be to further alienate hapu and iwi who are still to negotiate and settle. Equity. The exercise of fairness and equality will not be realised in a bill that isn't able to express the true essence of kotahitanga, whanaungatanga, kaitiakitanga, manakitanga, etc. These are expressed and provided for in Te Tiriti o Waitangi and are silent in this proposed bill. Our mokopuna, our taitamariki, our rangatahi, they have a right to be heard. They are intelligent and astute. They are proud and they are courageous. They have the reo and they have common sense. Common sense to know that this is wrong. They are also of a voting age, and that voting age is increasing. Just thought I'd put that in there. And sovereignty in Parliament, I just read this the other day, but sovereignty in Parliament is not the same, I suggest, as sovereignty being expressed in Te Tiriti o Waitangi. And the author of this bill should know the difference, needs to know the difference. Someone needs to explain it to him. I'm not sure if he'd be interested. Sovereignty between two peoples and nations is quite different to the sovereignty given through a general election. I'm not even sure if there's such a thing as sovereignty in government. That is my submission, my oral submission. To end, Ngāpuhi did not cede sovereignty, and I oppose the bill.
Lorraine, got several questions. The first from Mario Mino Kapakingi, then we're going to Todd, then Tracy.
Lorraine, tēnā koe, mihi ki tō whakaaro, an ka mau mai te whakaaro a patuone tēnā koe. In that regard, and to your submission, kaunui te mihi, you talk, and patuone referred to mokopuna, wana mokopuna kei te haere. And we know Ngāpuhi, the largest of all, iwi, hapu, and therefore our mokopuna, the greatest number, will come. How will this, in your mind, just a little bit more detail digging in, will this type of thinking and thinking impact on our mokopuna kei te haere?
The thinking of the proposed bill, or
Yes, yes.
I'm really impressed with the way our young people have responded with their intelligence. You know, it's quite easy to get really, really angry over all of this, but they're using their intelligence, and they're not leaving those behind that don't speak te reo. They're not leaving those behind who are not Maori, who are not Ngāpuia, that they're taking people with them. And I applaud them for that. But the thing is, they haven't been given an opportunity. Our young people, our mokopuna, have not been given an opportunity to express their thoughts on this proposed bill. I hope I've answered your
Tēnā koe.
Thank you,
Te mihi.
Lorraine. We'll go to Todd Stevenson, and if there's time, Tracy McClellan.
Thank you, Lorraine, and thank you for submitting this morning. I think we all accept people are born into different circumstances, have different abilities, etc. But do you think it's important that people are treated equally before the law and have equal protection before the law?
Well, I'm not a lawyer. And I'd like to think if I do need legal advice, if I do need to go and find some advice, I will be treated fairly. I'd like to think that. I'd like to think that the policies that are put in place are going to treat me the same as my neighbour, regardless of ethnicity.
Thank you.
I don't have that confidence.
Yeah.
Final question from Dr. McClellan.
Thank you.
Thank you,
And we're trying to
Lorraine.
clarify that.
Thank you, Lorraine. And you said something early on, much more eloquently than I'm going to attempt to restate it. But the general gist of it was, why now, when a deal, a agreement, a treaty has only now just started to be enacted, barely at that, why now is it time to pull the rug out and change the rules? Do you have any thoughts on why this is happening now, just when we're starting to get some momentum and actually honouring Te Tiriti?
You know what I think, honestly? It gets votes.
No.
Thank you, Lorraine.
Honestly.
So that's
Really?
it's a very succinct answer, and thankfully right at the end of the time. So appreciate you being with us here this morning.
Tēnā koe wā.
Kia ora, ka pai.
Going to go now to our submission from Judge David Harvey, who's joining us online.
Put my hand up now for a question, Mr. Chair.
David, thank you for joining us. We have you for 10 minutes this morning before the committee, so I'll hand over to you to begin your presentation.
Thank you. My name is David John Harvey. I'm a retired district court judge. I currently hold a practicing certificate as a barrister, and I have a Bachelor of Law degree, a Master of Jurisprudence degree, and a Doctor of Philosophy degree. I support the bill, and I believe it should proceed. It's a matter of such importance that I think it should be properly placed before the electorate by way of a referendum. I should say that although I'm a lawyer, I neither endorse nor support the submissions of the New Zealand Law Society and the New Zealand Bar Association. Turning to my submission, I focus upon Clause 6 of the bill, although it's critical to note that the bill does not in fact rewrite or amend the treaty itself. That is made clear in Clause 9. The committee, of course, will be aware of the principles that are contained in Clause 6. Principle 1 confirms the governmental structure of New Zealand in terms of what could be called a liberal democracy. Principle 2 secures property rights and by implication incorporates the concept of rangatiratanga, because that was a right that Maori enjoyed when the treaty was signed. Principle 3 provides for equality before the law and the equal enjoyment of fundamental human rights. The entablature of the United States Supreme Court building has the phrase equal justice before the law. That is what Principle 3 is all about. The courts, government and Waitangi Tribunal have developed a number of principles which it is argued will be excluded by the bill. I argue to the contrary. If we look at Principle 1, we have the power to govern New Zealand in the best interests of everyone. This incorporates the principle that the Crown has the right to govern. Edmund Burke considered that society is an enterprise that promotes the interests of all parties, and that partnership depends upon respecting those interests. The government, therefore, is a partnership between the people and the state, and thus the principle of partnership is necessarily preserved. As part of a partnership principle, there are a number of collateral elements. The active protection principle is inextricably linked to that of partnership. Given that Māori are a constituent part of everyone, the active protection principle ensures the protection of their interest. Implicit in any partnership is the principle of good faith dealing. If a government excludes good faith, it loses legitimacy and will fail. When there is a breakdown in a partnership relationship and wrongful acts are done by one partner to another, there is a right to recompense and adjustment, and thus that principle is present. The recompense principle is also recognised and given effect in Principle 2 of the Bill. Thus, in my argument, the existing principles of partnership, active protection, equity and fair dealing, and remedies for wrongs are included in Principles 1 and 2 of the Bill. I have approached the problem in the way that I have in an effort, I hope, to dial down the rhetoric and emphasise reason. And I am at your disposal if I can be of further assistance.
Thank you, Judge Harvey. We've got a couple of questions. First one from Willie Jackson, and then Rauri Waititi. And then
Kia ora, Judge. Kia ora, Judge. Judge, you're out of sync with the best legal minds in this country. That you'll be aware of that. The King's Council, the creme de la creme of legal minds in this country, who have come out unanimously against this bill. You're out of sync with the creme de la creme of political leaders in this country, like Sir Geoffrey Palmer, Sir Doug Graham, Chris Finlayson. I just can't reconcile this, Judge, given your background and your status. Where does this put you in terms of the legal fraternity? Because the legal fraternity seems almost unanimously against this bill.
Firstly, Mr. Jackson, not all King's Council are of one mind on this particular point. Point two, Mr. Finlayson made some interesting suggestions in his submission, as I recall. I wonder if he's looked at his watch lately, because in fact, we have daylight saving, which is a way in which time gets changed by parliamentary action. So the suggestion of parliamentary supremacy that he sort of disposes of so rapidly doesn't stand. It may well be that there are differences of opinion, Mr. Jackson. That's what living in a democracy is all about. I have approached this from the point of view of reason. Other people have approached it from the point of view of rhetoric and buzzwords. That's their privilege, of course. We live in a democracy. They have freedom of expression. It bothers me not one whit if I am out of sync with other people, or as you put it. I doubt that I am, but you're entitled to your opinion, as I am to mine.
Absolutely, Judge. Yeah.
Start from Willie, and then we'll go to
Yeah,
Rauri.
absolutely, Judge. I'll concur with that. Would you agree that this is an attack on the Māori tino rangatiratanga? That has been the constant criticism here. Do you agree with that?
No, I do not. And if you read my submission, you will find that.
Okay, thank you. Rauri, and then Todd, and then Darryn.
Morena, Judge. Thank you for your submission, firstly. And just to pick up on some of the stuff you talked about before I get to my question, especially around the equal rights for all in America. As we know, the civil rights movements didn't just come out of thin air and out of reason, to pull a rhetoric like that, where civil rights was only established in 1954 to 1968, I think does them an injustice. Māori are 30% of the people proceeded against by police, 45% of the people convicted, and 52% of the people in prison. And after that presentation, I understand why. Now, as a judge, do you respect the rule of law and 30 to 40 years of jurisprudence by the Supreme Court, by the Privy Council, by the High Court, by the Waitangi Tribunal, who have ruled in favour of Māori when it comes to treaty rights?
Do I respect the rule of law? Of course I do. But the point that you make is an interesting one, because if you read my submission and if you understand it, you will note that the principles that I have referred to are those that have been devised by the courts and by the Waitangi Tribunal. So there is no difficulty whatsoever in the incorporation of that jurisprudence into the submission that I have made. And I have said that those particular principles fold into this particular bill that is before the Select Committee at this time. So of course I accept the rule of law. It would be completely alien to my nature to feel otherwise.
If that's the case, then why would we have the need for this bill?
Because it's time that this sort of thing should be clarified. I think that there has been a lot of confusion about the way in which the principles of the treaty work. It is a matter which concerns every New Zealander and therefore should be put before every New Zealander.
Thank you.
That is why I support it.
Thank you, Judge. We're going to go to Todd and then Duncan and then Tamaka.
Thank you, David. Thank you for your submission. And I've got to say, I think it was very interesting the way that you've been able to incorporate the current principles of the treaty as it's understood into this proposed bill. But my question, I think it follows on actually just from what you said. I mean, you see this as a totally legitimate discussion for Parliament to be able to have and then in the future to go to a referendum of the New Zealand people.
Yes, absolutely.
Todd, Duncan and then Tamaka.
Kia ora, Judge. Look, I'm just interested to draw on some of your experience in the District Court, where I have no doubt that you had a long line of defendants in front of you.
I sat in South Auckland, Dr. Webb.
Yeah, so in light of that, you would have seen the disproportionate representation of Māori in our criminal justice system. And I'm sure you would have seen cultural reports. How do you reconcile that with the suggestion that we should be narrowing down the scope of the treaty?
I'm not suggesting for one moment that we should be narrowing down the scope of the treaty. I refer you to clause 9, which keeps the treaty in place. Furthermore, I refer you to the way in which I've developed my argument, which is that the principles that have been developed by the courts should be incorporated. The problem that we have, in my view, with the greatest of respect, Dr. Webb, is a political one. And it flows from the fact that successive parliaments, both Labour and National, have failed to grasp the fact that the changes that are needed to get rid of this terrible disproportion, and it is a terrible disproportion of appearances in court, is not a 3-year problem. It's a multi-generational one. It's going to take 25 years to solve, and it requires a concerted effort on the part of everybody to deal with it.
Thank you, Judge Harvey. So I'm sorry to interrupt, but that's the end of the time this morning. We appreciate you coming online and joining us early this morning. Thank you for your time.
Thank you.
Right, members, just before we go to the next submission, I just want to make 3 very quick points. If members can keep their questions succinct, we can get more questions in from other members. There are long lines of questions waiting. If you can follow the directions of the chair, ask your subs through the chair. Also help to maintain order, otherwise it's going to be a long 71 hours over the remaining hearing. And just thirdly, if we can avoid making reflections on the submitters. I receive a number of emails when reflections are made, and I receive enough emails as it is from my colleagues.
We like giving a review. Come on,
if you can
Mr.
take
Chair.
those 3 on board, we'll move to the next submitter, and we'll welcome submission from Sandra Goudie.
No
who's joining
opinions,
us
eh?
online.
We'll have a bigger team soon.
No, we've skipped ahead.
I thought I was sitting next to the greatest legal mind in the country.
It's
this gentleman, not Sandra.
Is it not? Sorry, no, sorry, I apologise. I was ahead. Sorry, it's submission from Te Runanga or Whaingaroa, and joining us is the General Manager Culture, Raniera Kaio. Raniera, kia ora, sorry about that. We have you before us for 10 minutes this morning. I'd invite you to begin your presentation.
Didn't realise it was the office.
Tēnā koutou e te komite. Ngāti Kauki Whangaroa, ngā puhiki Whangaroa absolutely reject the principles of the Treaty of Waitangi Bill. A bill that is only a breach of, that is not only a breach of Te Tiriti o Waitangi, but an elaborate scheme orchestrating division to justify its oppression of Māori. The bill is an act of transparent deceit, a continuation of Crown's historical pattern of land theft, deception, and political manoeuvring. We see the game being played here: divide Māori and Pākehā, fuel racial tension, and use that manufactured conflict as justification to erase Maori rights. We refuse to stand idle. Whangaroa refuses to stand idle while history repeats itself. The Crown strategy has never changed. It erodes Māori rights incrementally under the pretense of legal reform. Te Tiriti of Waitangi was supposed to guarantee Māori tino rangatiratanga, absolute authority over our own affairs, yet the Treaty Principles Bill strips those guarantees away, replacing them with vague, political, convenient principles designed to benefit only the Crown. The Waitangi Tribunal's ngā mātāpono, the principles, clearly states the bill severely breaches the treaty, undermining its constitutional role. It dismantles the enforceable rights of Māori, leaving them subject to the Crown's whim. We have seen this strategy before, and Whangaroa Hapu have suffered deeply because of it. The first theft, pre-treaty land transactions in 1833, William Parrott and William Spickman claimed ownership of 100 acres of Whangaroa land in exchange for a double-barreled shotgun. The beginning of Pākehā trickery, manipulating rangatira into transactions that were later used to justify large-scale land theft. The second theft, the Native Land Court. Established under British law, the Native Land Court was a weapon of mass disposition. Whangaroa Hapu were forced into individual land ownership, making it easier for the Crown to divide and conquer. In 1866, for example, Ngāti Uru lands at Te Rā Kaurere were taken through Crown grants issued under dubious legal claims. The third theft, continued Crown deception. The Crown exploited Māori willingness to engage in trade to further entrench its power. The economic capacity of Whangaroa was deliberately undermined by controlling trade routes and limiting Māori access to commercial opportunities. This is the same blueprint being used today. The Treaty Principles Bill is not new. It is the latest chapter in a long history of orchestrated Whangaroa and Māori subjugation. We refuse to let this cycle continue. The Crown's erasure of Hākaputanga. Before Te Tiriti o Waitangi, our tūpuna already declared their sovereignty through He Hākaputanga o ngā rangatira o New Tireni in 1835. The Treaty Principles deliberately ignores He Hākaputanga because acknowledging it would mean that admitting that Māori sovereignty was never ceded. Whangaroa was a key site of Māori resistance and self-determination. Hongi Hika in the defence of Māori sovereignty. Hongi Hika, one of the most formidable rangatira of Whangaroa and Aotearoa, understood the dangers of Pākehā colonial encroachment. His military campaigns were not acts of aggression, but strategic defences of Māori authority. Hākaputanga and Whangaroa leadership, Whangaroa rangatira, were active participants in Hakamenenga o ngā hapu, the Confederation of United Tribes. The collective leadership was an assertion of Māori independence and self-governance, directly contradicting any claim that Māori consented to British rule. Early petitions against land theft, as early as 1839, Whangaroa rangatira such as Hemi Tupe were writing to the Crown to prevent their district stretching from Matauri to Whangaroa from being taken. Yet, despite these explicit statements, land continued to be stolen under false premise that Māori were willingly selling it. The Treaty Principles Bill is a continuation of this erasure. By removing Te Tiriti's legal weight, the Crown is attempting to rewrite history, pretending that Māori's sovereignty never existed. Whangaroa refuses to allow our ancestors' sacrifices to be erased. We demand that the committee immediately withdraw the Treaty Principles Bill. This is a political ploy designed to remove Māori rights. It must not be allowed to proceed. We demand that the committee formally recognise Hākaputanga. And the sovereignty declared in 1835 must be acknowledged and upheld. We demand that the committee cease the Crown strategy of deceit and division, that the government stop using racial conflict as a tool to justify the continued dismantling of Māori rights. The Treaty Principles Bill is an insult. Is an insult to Māori, a disgrace to Aotearoa, and a violation of fundamental human rights. To this subcommittee, I say this, history will judge you. You have a choice. Uphold the truth of Te Tiriti o Waitangi, or be remembered for supporting a colonial coup against Māori sovereignty and the continued subjugation of Hapu rangatiratanga. Ngāti Kaio ki Whangaroa and Ngāti Kaio ki Whangaroa, Ngāpui ki Whangaroa reject this bill outright. We will not be silenced. Withdraw the bill now. Tēnā koutou.
Raniera, we've got a question from Māori Mino Kapkingi and then Todd Stevenson.
Thank you. Tēnā koe Raniera, me mihi ki tō whani. Raniera, so the Prime Minister declared yet again at Ratana he will vote this down, him and his team. The Honourable Shane Jones, your uncle and my whanaunga, have said the same. E te koroneihana, we will vote this down, it will not go further. Whaingaroa, we need 252 homes across the whole of our area. The resource that's used for this exercise, which could well be used in Whaingaroa, what do you say to that?
I understand through figures that have been put out and statistics that have been put out that should all 300,000 submissions be read, it would take one public servant 19 years at a cost of about, as you say, $4 million. That's resources that could be utilised in a health sector that's been stripped, in an education sector that's been stripped, in a housing sector, as you say, whai maria meno, that Whaingaroa could well do with, that Te Taitokerau Whānui could well do with the support and the resourcing to house our people on lands that they've been alienated from for many a generation. Nā reira, process like this that costs the money that it does and the resource that it does is not only an insult to Māori, but I think an insult to the intelligence of Aotearoa Whānui and all New Zealanders.
Tēnā koe.
Raniera, we've got a question from Todd Stevenson, then Tampa Paul.
Thank you for your presentation. Do you think that the treaty does guarantee different rights based on ancestry?
I believe that the signatories of the Tiriti o Waitangi did so in their belief to protect the descendants thereafter, to protect the rights and tino rangatiratanga of descendants thereafter, to ensure equality, equity between Māori and those that were looking and seeking to come into and onto our whenua.
Thanks, Raniera. Final question then from Tampa Paul.
Morena Raniera, my question is, in your submission, you make three main points. Your third main point is a legacy of Crown breach and Māori resilience. Just on that word legacy, what do you think that this bill and all of the other bills that are coming through this parliament right now, what kind of a legacy do you think that the government and its three government parties are leaving in Aotearoa?
Stay in English, but I can't think of an English answer to this, so I hope the interpreter's listening. He pire pai tini tēnei. Ka rongo tēnei pai tini e te katoa. Ka ngaua te reo Māori, ka ngaua ngā tikaka Māori, aini ka ngaua noki te āhuaranga o te noho take ki tō tātou ake nei whenua. Ka ngaua tēnei pire pai tini, i tēnā whānau, i tēnā hapu, i tēnā iwi huri i tō tātou nei whenua. Koia, ko te haka kitenga e kia nei koe. Koia, ko te whakahekenga e kōrero nei koe. Ahaere ake nei, ahaere ake nei, ahaere ake nei, ātutukino. Ka rongo tēnei paitini e te katoa. Haunga a Māori nahe. Engari, ngā iwi take katoa, o tēnei moana tāku e kīnei. Nā reira, mukua tēnei pire.
Thank you, Raniera. Thank you for your submission. That's your time this morning. We appreciate you being with us and providing a presentation. We'll now go to our submission from Sandra Goudie. Sandra is joining us online. Good morning, Sandra. Thank you for joining the committee. We have you for 10 minutes this morning, so I'll invite you to begin your presentation.
Thank you, James. I'll just launch straight into it. There is actually no authoritative copy of the Treaty of Waitangi Principles as stated in writing in 2023 by the then Attorney General David Parker and reiterated by the then Prime Minister Chris Hipkins. The government refers to principles in law,
but cannot produce them. And a sad truth is that we need to establish principles of the Treaty of Waitangi because we cannot trust the government to uphold the rule of law and ensure we are all equal in the law. And that's the government's greatest treaty breach of all. The government should not continue to ignore the broader responsibility of the Crown in its representation of all New Zealanders as a party to the Treaty of Waitangi. There is no partnership, as some Māori would have you believe. That is merely an attempt to exclude non-Māori from the dialogue. And the latest discussion paper from DOC is a classic example of the neglect around principles. Rather than amend the Conservation Act Section 4 or establish treaty principles, the current government is going to entrench prejudicial bias in favour of Māori on the pretext of their giving effect to the principles of the Treaty of Waitangi blunder. Queen Victoria's Royal Charter of 1840 declared New Zealand an independent colony of Australia and established a democratic parliament. That preceded the Treaty of Waitangi. One could argue that it is the Royal Charter which is the founding document of New Zealand and not the Treaty of Waitangi. Regardless, Queen Victoria reinforced the rule of law in both documents where all were to be treated equally and at that time as British subjects. In spite of that, there is now an unprecedented emphasis in favour of Māori within the law, giving rise to an unacceptable level of expectation, privilege, and growing demand for more by some Māori commensurate with a growing hostility and lack of respect for others. The Y262 claim, alongside the He Puapua document, is driving to entrench the idea of a partnership with the Crown to the exclusion of all non-Māori, undermining both the rule of law and our democracy. Breaches of the rule of law and thus Treaty of Waitangi obligations are the reason we need principles that support and are consistent with the rule of law. Non-Māori as treaty partners do not have a Waitangi tribunal to go to if they feel affected by any perceived prejudicial bias arising from any action of the government, but Māori can. While we must absolutely resolve historical treaty claims, the Treaty of Waitangi Act Section 6 allows Māori to challenge any action of the government on a continuing basis, demanding more and more of our hard-earned taxpayer dollars and preeminence in the law, contrary to the rule of law and the Bill of Rights Act. We each of us have our own tikanga, our own kaupapa and our own matauranga. These things are not exclusive to Māori. They are just Māori words whose meaning can be applied to anyone. There should be no special privilege in law for consultation, payments, or requirements for agreements. There should be no special privilege in law over anyone else's private property. There should be no coercion of any kind in any form to have to accept someone else's cultural paradigms, tikanga, kaupapa, matauranga. The days of handouts for resource consents and at building sites should be over. Other provisions for Māori in the RMA are totally unacceptable and a major breach of a Treaty of Waitangi statement on the rule of law and also the Bill of Rights, with any objections or concerns falling on the deaf ears of successive governments. Non-Māori have no Waitangi tribunal. This is why the rule of law should be applied equally and not give special protection to only the thinking, the tikanga, the kaupapa and the matauranga of Māori. Ignoring the definitions or meanings of words does government officials and parliamentarians no credit. The Ministry of Justice and the Law Commission should know better. We need principles to avoid the growing chasm swallowing hard-earned taxpayer dollars. The Waitangi Tribunal is lobbying government to establish a specific fund dedicated to Treaty of Waitangi claimants. Couple this with Section 6 of the Treaty of Waitangi Act, whereby Māori can challenge any action of the government on the basis of prejudicial bias, and taxpayers are gifted with a gravy train of demand, eating up hard-earned taxpayer dollars better spent in health, education or policing. DOC is always crying poor, but millions of their dollars are being paid out on 35-year Ngā Whenua Rahui grants to Maori landowners and other grants payments. Just shy of $500 million spent on the Labour Party's creation, Te Arawhiti and Māori development for the 24-25 financial year, plus many more millions over the 4 years, and the list goes on. Not to mention the huge millions and millions of dollars spent prior to that. No wonder we cannot employ nurses with so many having to leave the country. Maori businesses only pay 17.5% tax. Other businesses pay 33 to 39%. And to top it off, the Ministry for the Environment said it would accept retrospective claims in regard to the Waitangi Tribunal kaupapa inquiries. New Zealand cannot afford this gravy train. It is time to do the right thing. If the government does not establish principles of the Treaty of Waitangi consistent with the rule of law, then every reference to the principles of the Treaty of Waitangi must be removed from all legislation and regulation, with the original statement, have regard to the Treaty of Waitangi, being all that is required. It should never be left to the courts to decide. Parliament fails in its fiduciary duty when it does not uphold the clarity and efficacy of the law along with the rule of law. Parliament must delete Section 6, 1, 2, 3 and 4 of the Treaty of Waitangi Act and introduce a sunset clause for the conclusion of historic claims and thus the Waitangi Tribunal, or allow non-Māori to make a claim against breaches of the treaty by the Crown. And where a treaty settlement condition affects a constitutional, governance or Bill of Rights matter, a referendum must be held at the election following enactment of the settlement, by which the public can vote to uphold or vote down that provision. I support the referendum and principles of the bill.
Thanks, Sandra. We've got 3 questions lined up. First from Todd Stevenson, then Samantha Paul, and then Kushla.
Hi, Sandra, and thank you for your submission. There was a lot in that. I suppose just to come back to one of your earlier points, it seems to me, and you gave a lot of examples, but it seems to me because the principles of the treaty haven't been defined, and you mentioned actually former Attorney General and the Leader of the Opposition making similar comments. There is no authoritative copy of the principles. Is it your submission that that's what's led to a lot of the issues you've raised? It's just this uncertainty?
It's not uncertainty. The government cannot produce any principles of the Treaty of Waitangi. I have asked for them in writing. I have been given a written response back from David Parker and Chris Hipkins. They cannot produce them. So if you're going to write a reference to principles in law, you should be able to produce them. That's a requirement, a basic fundamental requirement of the clarity and efficacy of the law, which the government has consistently failed to honour. And without those principles, you're going to start getting the sort of disgruntlement or an unequalness within the law that's currently happening, and it's getting worse. And we can't afford it. People don't understand the amount of money being spent here.
Thanks, Sandra. We'll go to Samantha Paul, probably last.
Kia ora, ata Māori e, Sandra. My question is, your submission just now and this one in writing is all about Māori, and I just wanted to ask, what qualifies you to speak about Māori? Do you have an area or a qualification or a lived experience to speak about my people?
My own life experience gives me the right to actually speak about any matter or subject that I so choose to.
So it's your life experience.
I do it with all respect.
It's your privilege.
Checks out. Thank you.
Thank you, Sandra. I'd like to extend the committee's appreciation for you being
An apology from my colleagues.
Appreciate your time.
Don't apologise to me. You got no right to speak for me either. No, you do not.
That won't be the only thing you apologise for.
Don't apologise to me.
Apologise for this.
You don't have the right to apologise to
Thank
me.
you.
All right? I'm just letting you know that now.
ITD, if you continue, you won't have a long time here in the committee this morning, and one of your colleagues can have fun instead. Okay? Everyone's going to calm down a bit. Follow the instructions of the chair earlier on. when I ask supplementary questions.
Yeah, but I have nobody speak for me,
I'm
Mr. Chair.
I'm speaking, I'm
Excuse
making
me,
a
no.
ruling on the disorder that was just caused by the committee.
Yeah.
If it continues, members will be asked to leave the room and their colleagues can enjoy the rest of the day instead of them.
What's a genuine question?
Thank you. We're going to move on to the next submitter. The next submitter now is the Hon Kiri Allan, who's going to join us online. Kia ora, Kiri, good morning. It's really nice to see you. Thank you for being with the committee. You know how this process works. I'll hand over to you for the 10 minutes to provide us with your presentation. Sorry, you're on mute, mate.
It's like my uncles reminding me they're on mute. Tēnā koe, James, o tira kia koutou ngā memo tēnei komiti. He uri tēnei o Ngāti Rangi Nui, Ngāti Rangi Tūwhare Toa Te Raroa Hoki. My name is Kiri Allan, and I'm opposed to this bill because it is a simple abomination. It seeks to erase Māori from our own history books and in our own lands. This is not just about erasing 50 years of treaty jurisprudence that has evolved since 1975. This is a bill that is about scrubbing us from history. This bill highlights a constitutional crisis. Te tiriti o Waitangi is a fundamental tenet of our constitution and is the fibre of our nation that weaves us together. But this bill is a result of coalition negotiations. This bill is a representation that up for grabs in coalition negotiations are the core components of our constitutional arrangements. This is an unjustifiable decision by those seeking power to enable the unwinding of the constitutional status of Te Tiriti through this bill and in this manner. Our constitution underpinnings should not be considered that cheap by those vying for power. Further, the bill erodes and undermines every undertaking made between the Crown and Hapu and Iwi. Right from the promises made in 1840 to the more recent promises made by the Crown to Hapu and Iwi through the treaty settlement process. Despite poor attempts to preempt judicial inquiries out the wazoo into treaty settlements, this bill will simply open them up. It will simultaneously breach whilst purporting to protect settlements in the same breath. Every single treaty settlement contains an apology by the Crown to Hapu and Iwi for the wrongdoings of the past and an undertaking to work together to forge a treaty-based partnership moving forward. The mere action of allowing this bill to come into this House is a breach of those promises. Now, the Crown may wish to wash its hands of Te Tiriti because of the treaty settlements process, but the settlement process was not a precursor to the eradication of Te Tiriti o Waitangi from our constitutional framework. Now, there are two ways to mobilise people in politics: provide a vision based on hope, or create an environment of fear. This bill is a populist bill that strikes at the heart of fear. This bill is intended to incite the fear that Māori gain from Te Tiriti in ways that other New Zealanders don't. But that is a simple lie. It denies the history of our nation. It denies the fact that everyone has a place in this country because of Te Tiriti o Waitangi. And no one loses because we are a nation that honours our history. There have been sustained calls from proponents of the bill that there needs to be a conversation about what the treaty principles are. The reality is that this has been a sustained conversation about Te Tiriti since 1840, and an independent commission of inquiry was established in 1975 specifically to inquire into what Te Tiriti means in a contemporary context. The architects of those bill may find those interpretations by both the courts and the tribunal as an inconvenience to their ideology. So they have crafted their opposition in part on the basis that Te Tiriti creates legal uncertainty today. Now, the architects of this bill may find legal history in this country inconvenient. The minister responsible for the bill 2 days ago stating that Hapu and Iwi lack sovereignty to enter into a treaty, despite the fact that Hapu and Iwi had signed Te Whakaputanga, crafted by Busby, in asserting that Māori were a sovereign people. As the Cabinet Manual states, a treaty is a written agreement between states that creates obligations for those states that have expressed their consent to be bound. The Crown expressed its consent to be bound by entering into Te Tiriti o Waitangi. It is a privilege to exercise executive decision-making powers, and with privileges comes responsibilities. As the Minister of Conservation, I had the responsibility to ensure that Section 4 of the Conservation Act, that requires that the Act is to be interpreted and administered as to give effect to the principles of the Treaty of Waitangi, was complied with. There is both a principled and practical history to such clauses. The Department of Conservation administers 1/3 of the landmass in Aotearoa, and, for example, this comprises lands that were taken by raupatu, illegal land confiscation. It includes the administration of taonga, birds, trees, fisheries, kōiwi such as whale bones, and much more. Māori, hapu, and iwi were guaranteed te tino rangatiratanga o rātou whenua, o rātou kāinga, me o rātou taonga katoa. The English text guaranteed the full, exclusive, and undisturbed possession of their lands and estates, forests, and fisheries. The Crown has accepted that raupatu was a breach of Te Tiriti o Waitangi, lands that were taken wrongfully and, to date, are yet to be returned. The Crown, if the bill was to be enacted, Section 4 would be stripped of any meaning and effect. It becomes a hollow and meaningless clause. Now, this bill is but one part of a comprehensive strategy being deployed by this government, led by its coalition partners, to eradicate Māori as part of our legal and cultural landscape. Whether that is through our reo, evolution of resources to enable equitable outcomes for Māori, or the treaty clause review, the regulatory standards bill, and this bill's express intent to eradicate, for all intensive purposes, Te Tiriti o Waitangi. For the reasons set out, I urge all members to oppose this bill and make the recommendation that all legislation contain a clause that each act shall be interpreted and administered as to give effect to Te Tiriti o Waitangi. I'm happy to take questions.
Kia ora, Kiri. Thank you for your presentation this morning. I'll offer the first question to Kusha because we didn't get to it before. If you don't have one, I'll go to Takata first.
Tēnā koe Kiri, pai te kite atu i a koe. Our last presenter came from a very different angle to you, but she kept referring to Labour as the government. In your opinion, what are some of the most positive initiatives that have come out with regard to treaty principles in the past? And how do you see the damaging effects of what could happen now?
Well, Te Tiriti is about a partnership in some regards, right? And so, for example, I can use many examples, but Jobs for Nature was a great initiative that enabled Māori to be able to work their whenua. It enabled Māori to be able to reconnect with maunga, awa, because there had been that disconnection for many years. It enabled the devolution of resources to initiatives like whānau ora. Te Tiriti o Waitangi has created many positive implications for our people, all New Zealanders, and this bill is an absolute slight on that history.
Kia ora, Takata, and then we'll go on from Todd.
Tēnā koe, kiri ngā mihi nui, kia koe me o mahi huhua I roto I nei tuāhuatanga. There just is an apparent lack of understanding amongst the people who support the bill. You and I will know that it's called a treaty. It's the Treaty of Waitangi, not the Contract of Waitangi, because treaties are the things that bind sovereign nations. So the sovereignty of Te iwi Māori shouldn't be in question. But it seems to still be the case. And so the treaty is entirely constitutional in nature. So what in your opinion, what sort of jeopardy does this bill present to the erasing of Te Tiriti o Waitangi I'm talking about? What sort of jeopardy does that present to the constitutional rights of all New Zealanders to be in New Zealand?
Te tiriti o Waitangi, as I said, is a part of the fibre of our nation that weaves us together. Now, to enact this bill would eradicate the undertakings and the promises that our forebearers made to each other. It undermines and unwinds the constitutional status by dint of a coalition-agreed bill. These protections afforded to our constitution simply cannot be unwound because of political posturing.
Kia ora.
If it's
Very quick question, yes. Thank you for presenting. Todd Stevenson here. Just at the end of your submission, you said legislation going forward should use the term give effect to treaty. So are you saying that should be different from the principles of the treaty? I just want to see if you actually a distinction.
I'm saying that each bill should give effect to te tiriti o Waitangi.
So not just the principles.
Te tiriti o Waitangi.
Yeah. Okay, thank you. Just wanted to check that.
Thank you, Kitty. Thank you for joining us this morning. It's really good to see you again. Hope you're well, and we appreciate you being here.
Kia ora, James.
Okay, folks, we're going to now invite John Milne up to the table. John is going to write us the submission first. And John, good morning. Thank you for being with us. We have you for 10 minutes this morning, so I'll invite you to begin your presentation.
Thank you, Mr. Chairman. Excuse me. And good morning to committee members. I'm an economist, a chartered accountant, and a businessman. I take it that my submission has been read. This is a supplement to that in the light of subsequent events. My career spans two phases. The first is some 32 years with a shell group of companies around New Zealand, the UK, Southeast Asia, and the Philippines. When I retired from Shell, I came back to New Zealand and have had a number of directorships in private companies, listed companies, two listed companies, an SOE, which I'll return to. I've been involved in a local authority audit committee. I've been chairman of Hei Huarahi Tamariki, Aotearoa, of that trust. And the experience I've had over some 40 years informs this presentation and my submission, complements it. After in anticipation of retirement, I actually went to the University of Sydney and obtained a PhD in business finance. Now, since delivering my submission, the government has announced New Zealand is now open for business, for growth, and for overseas investment and finance. And that is after slipping to 33rd out of 37 in the Economist country ranking last year. So my submission in support of this bill, and most importantly, in the general policy statement supporting the bill, which is its preamble, is therefore an added dimension. It is the chance to eliminate sovereign risk arising from our legislation or mitigating it. My submission, I refer to in paragraph 4, some of the considerations that people try to mitigate sovereign risk, as well as conditions that are applicable. And I think that the importance of sovereign risk is actually a very important issue and should not be underestimated. I could elaborate, if you wish, on 3 areas of my personal experience where sovereign risk has been an issue. The first was in the Maori joint venture agreements, where the Crown changed its opinion on a certain matter, and I can explain what happened, but that was a clear breach of the Maori agreements. The second one was the breakup of the Malaysia Federation, when Mahathir unilaterally declared his Bumiputra policy, and which basically denied access to business for Indians and Peranakan Chinese, and that caused the breakup, partly caused the breakup of the Federation, and Singapore and Brunei left the Federation. After the Marcos era, I was invited to go to the Philippines to try and bring back international financing agencies, banks, in support of our refinery project, which was some $665 million US. And that involved nearly 5 years of negotiation, to give you some element of why this sovereign risk is a really important issue. It involved bringing back a consortia of 6 different banking arrangements, involvement with UK law, with US law, with Filipino law, and considering in paragraph 4 the arbitration opportunities that presented in Malaya, in London, in New York, and in Australia. So that's where I'm coming from. On my return here, I was invited virtually immediately to join the SOE development group. Now, that was where a group of us were invited to present in 3 months a business plan and project to take over some of ECNZ's assets that they no longer wanted. And in the 3 months, we produced a business plan and a viable basis to form what became Contact Energy. I was an inaugural director. The government agreed, and we therefore were in business, just the 4 directors. The only time in my career there's only been 4 employees in the company. And we set about going to Wairaki. We sat down, invited and sat down with a Whaingaroa iwi advisory representative and asked them what were the principles of the Treaty of Waitangi, which we regarded as part of our license to operate, social license to operate in using some of their assets, namely the geothermal field and everything related to it. His reply was, and I'm sorry, I can't remember his name. We were recommended to act in good faith, responsibly, and to consult, subject to commercial considerations, about our operations and plans for the Wairaki geothermal field and the elderly Wairaki station. From my experience, therefore, this bill is timely, it's relevant, and it's important, with the added opportunity to help ameliorate sovereign risk relating to the undefined principles of the Treaty of Waitangi, which can affect New Zealand as a potential investment destination. In summary, therefore, I am in support of the bill and its policy statement to remove uncertain sovereign risk criteria from potential investment. The referendum, if approved, would provide additional legislative certainty for investors, for citizens of New Zealand, and the business community. Per my submission, I think the bill needs further elaboration in the interpretations clause 4. And finally, I urge the committee to ensure clarity on amendments ready for legislative consideration as its prerogative and duty and responsibility. Now, I've got 2 other brief comments, if I may, Mr. Chair. In investigating the history of the treaty in the last few days, I would draw the committee's attention to 2 essays by Sir David Baragwanath in the February 2024 New Zealand Law Journal on these matters. Like Siraparana Nata, which I refer to, and I've got copies of Siraparana's Treaty of Waitangi, if you wish. He is probably New Zealand's leading jurist and legal mind. His essays opine, for example, there are 4 parties to the treaty, not 2. Now that will surprise you. And he gives his reasons. Moreover, he says the preamble to the treaty, rather like the preamble to this bill, is an integral part of the treaty, but it is rarely referenced. And I suggest one looks very closely at the preamble to this bill. And what he says, it should be integral to the treaty articles in accord with Article 31 of the General Rule of Interpretation in the Vienna Convention of the Law of Treaties, to which New Zealand is a signatory. I've read this submission to you. I note that for legal reasons, I have read his submission to you. I note that for legal reasons, he does not support the bill as presented. So I just want to give you that counterbalance. I also commend to you the anthology attached to Dr. Bryce Wilkinson's submission to you. He details relevant reference material, which includes Sir Aparana's explanatory document, as well as Sir David's two essays, and various other correspondence. And they're not going to be necessarily covered elsewhere, and I suggest you do read that anthology. I think it's quite important. Thank you for your time.
And thank you, John. We've probably got time for one question from Tim.
I'm sorry,
who was first in, so it'll have to be a very brief
Yep,
question.
so 7 out of 13 of your paragraphs in your commentary on your submission are about Ta'apirana Ngata. You said he's one of the greatest, you said he's Māoridom's greatest leaders. Which other Māori leaders have you researched to inform your view on this
Well, I
bill?
haven't researched, but Sir Peter Buck, Sir Maori,
Any contemporary ones?
Sorry, that's enough time for this point. Sorry, John, we're out of time, so that's the 10 minutes concluded. So
apologise.
I'd like to thank you for your submission this morning and for being with us. We're going to move on to our next submission now from the Council of Medical Colleges, and we have the team here in Perth. So I'd like to invite up to the table Dr. Murton and Dr. Lambert, who are going to present this submission to us. Again, I'll just remind members of the gallery, whether they be members of the public or members of Parliament, you are observers in the proceedings and not participants. If you'd like to join us at the table, sub in if one of your colleagues will run for Parliament, but that's how the process is looked today. Thank you, Dr. Murton and Dr. Lambert. You've got 10 minutes with us this morning, so I'd invite you to begin your presentation.
Kia ora, tēnā koutou katoa, ko whitere te monga, ko raukaua te moana no Parramatta aho, ko Paul Roia, ko Epi Oku Matua, for Samantha Murton Tokuingoa. I'm known as Sam by many people. I'm chair of the Council of Medical Colleges. I grew up in Wellington, did 4 years of medical training in Dunedin and came back to Wellington and spent a lot of time doing surgical procedures and then moved into general practice and have been chair of the College of GPs and the president for the last 6 years. That's coming to an end in July. Many people will be pleased to know. And I have been chair of the Council of Medical Colleges for the last couple of years and have spent all of my medical career working in hospitals and in the community, trying to do the best for all of my patients, including Māori who have very specific needs. And from a Council of Medical Colleges perspective, we oppose the bill because there are potential to enormous health impacts for Māori, and we think that if we do this, it will set us back many years. And I'm going to pass to Jo, who will introduce herself and continue the conversation. Thank you.
Roia hoa. Morena, ko tainui te iwi, ko tainui te waka, ko perongia te maunga, ko waipa te awa, ko purikiri, Ngāti Mania poto te hapu, ko purikiri ki te marae, ko Lambert, rawa ko Reynolds, Oku Matua, ko Joe Lambert tōku ingoa. Thank you so much for your time today and for this kōrero. I'm very proud to represent the Council of Medical Colleges in opposing this bill. 25 years as a doctor, I've worked all across the Motu, Otupoti, Dunedin Hospital, in community clinics in Whangarei, Tauranga, North Shore, Tamaki Makaurau, Auckland. The majority of that time has been with wahine Māori and sexual assault medicine. It's not fun. And unfortunately, it's overrepresented. For the last few years, I chair the College of Sexual and Reproductive Health, which is in charge of the advanced medical training for specialists working in that field, and also has a large membership of nurses and midwives. that we are training in that field as well. The majority of that time has been teaching cultural safety, hauora Māori, te tiriti, and how that impacts on the well-being of Māori. Tā Mason Jury uses the term hauora, and he describes that as flourishing. So when we talk about hauora Māori, we talk about flourishing for Māori. The last 3 years I've been working as Māori health lead at Te Tokotumai, Auckland City Hospital, where I've been te tiriti in action with a number of other Māori health clinicians, managers, administrators, and care navigators. And a lot of that time, I'm speaking with senior healthcare professionals who say to me, sometimes, some of them say, I'm culturally safe because I treat everybody equally. And I take a breath and I say, let's start there then, because equality assumes that we all have the same experience, that we all have the same resources, the same privileges, that we come from the same background. And if I apply that in a health setting, using the principle of equality, that would mean that if someone comes in with vomiting, let's say, whether they're a 6-month-old peppy baby, whether a 12-year-old male, a 30-year-old person with a uterus, or an 80-year-old, that I ask them the same questions, I order the same investigations, I give them or offer them the same advice, and I offer them the same medicine. By using the principle of equality, I would be wasting resources because 3 out of those 4 people don't need a pregnancy test.
Exactly.
Because I possibly could kill 2 of them, the baby and the older person, by giving the same medicine. Amongst other things, I could get an incorrect or missed diagnosis. In health, we have to take in all things. We have to take in ethnicity. This bill willfully ignores the data for Māori health statistics. Luckily for us, Te Tiriti already has the answer. Article 3, o retitanga. Equity. Equity asks us to be brave, to be vulnerable, to examine our privileges and examine our biases, whether they are unconscious or conscious. Equity looks at where we came from and how we got there and who brought us in and whether we could actually pay for our parking. The Council of Medical Colleges has spent the last few years a lot partnering with Te Ora Māori Medical Association and supported by the Medical Council of New Zealand, bringing us closer together. We've done transformative action for culturally safe care, asking our 9,000 members to understand and use Te Tiriti in their everyday clinical practice. This bill sets us back decades. This bill ignores that Māori are dying, and they're at the bottom of the waiting list to be told that they're dying. Now that sounds inflammatory, and I assure you it's not, because I've sat in the planned care hui and I've listened to wahine Māori waiting for 190 days compared to Pacific people waiting for 120 and other waiting for under 100 days. That's the data that is available for the government and for you all. I enjoyed Kiri's speech because she connected us back to whenua. And in health, in our advanced medical training, and in our undergraduate medical training, we talk about te whare tapawhā. And the whenua is the whare, the house of health. All the land that we are getting back and have got back through good use, the Waitangi Tribunal is allowing us to get our Māori health back. The whenua, which Kiri talked about, is deeply connected to health. Our language, Aotearoa, talks about the whare tangata, which is the house of the people, but also the uterus. The whenua is the placenta, and the whenua is the land. Our language already tells us what we need to be doing, and that is opposing this bill, which replaces equity with equality, and will risk, and does risk, the health and well-being of Māori and of all New Zealanders. I really want to thank my partner, because we are partners and partnership is really important. And I've learned that allies, wherever they come from, in Aotearoa are a huge, huge asset.
Thanks, Jo. And thanks for your time. We truly believe that if this bill goes through, then it will disable many of our healthcare workers to be able to provide a nuanced healthcare service to the people who need it the most. Yeah.
Thank you, Jo and Sam. There's no time for questions remaining, so we'll
Aloha
just
mai.
extend our gratitude. It's your time to use, as you see
Yeah.
fit. So just thank you for being with the committee. We appreciate your time this morning.
Kia ora.
I'm just going to move now to our last submission for the morning hearings, and that's an online submission from Maringi James.
Tēnā tātou katoa, ko Maringi te rangi a Tahua James, e rua te kaumatahi o kutau. Huri tēnei no te aroa whānui, no tūhoi, no tainui waka, anō hoki. Kua whana ke au I raro I te korowai aroha o taku hāpuri o te kautu, o taku iwi o ngā tivakaue, anō hoki. Nā taua wai marie nui ko mātou kuaku whanaunga, te whakatinanatanga o ngā wawata nui o tō mātou kāinga. Tēnei te whare tapu o te amohau, te ahi o ngā uri rangatira e whitawhita tonu ana I ngā whakareanga o kiwi te amohau. Ko tētahi o ngā tino mā tāpono kua noho hei tu apapa I wainga I a mātou ko taku whānau, ko tēnei mea te ngākau aroha me te ngākau whakaute ki te tangata, aha kua kōwai, aha kua nōhea. He take I tai mai ai tātou I te rangi nei, te tuāpapa o taua ngākau aroha, o tira o taua whakaro nui ki ngā tāngata katoa. Ko te tiriti o Waitangi tērā. Nā te tiriti o Waitangi I kotahi ai, o tira I paingatia ai tātou ki ngā whenua taurikura o Aotearoa. E mihi ana ki a tātou kua tai mai I runga I te karanga o te kaupapa, heoi kaore au te mihi ki te kaupapa. E te minita David Seymour, e te Hunga Hobson's Pledge, e ai ki tēnei pire, koe nei te whakatinanatanga a ngā kōrero a Hobson I aia e hariru ana I ngā hunga I haina I te tiriti o Waitangi. Ana e tika ana te kōrero a Hobson. He iwi tahi tātou. Engari he iwi tahi tātou ki runga I ngā whenua Māori. No reira whakarohia tērā I a koutou e whakatairanga ana I enei whakaro, mana kore, whakaute kore, ki ngā ki taurangi o tēnei whanaungatanga. Pērā ki ngā tau 1970, e hikoi tonu ana ngā mokopuna I ngā hikoi a ngā kaumātua. Ā, e kore tēnei ahi e weto. Ka tahu ki roto I ngā whakareanga Māori haere nei te wā. Ka ora tonu mātou, ake, ake, ake. Ka huri ki te reo o te iwi whānako whenua, kia marama ai te katoa. As one of the few rangatahi presenting to this bill, I want to acknowledge the fact that I'm presenting today. Out of 300,000 submissions, I feel incredibly fortunate to be one of the few chosen to speak. While I can only speak for myself and my kaupapa, I hope that what I have to share resonates not just with this committee, but with the many people watching and listening across Aotearoa. I've been watching the submissions this week. Some have been sharp, insightful, and grounded in truth, not just legal truth, but the kind you feel in your bones when you know something is right. I've listened to people who have spent decades studying, teaching, and fighting for this kaupapa, and I've been reminded that mātauranga doesn't just sit in universities or archives, it lives in our people, in our stories, and the way we continue to stand when we shouldn't have to. Te Kanawa Wilson, one of the only other rangatahi chosen to present, didn't just talk about te tiriti, he talked about what it means to live it, and that's something no law, no policy, no bill can take away. And then, of course, there have been the other submissions. Some have read less like arguments and more like Facebook comment sections brought to life. The wild assumptions, the bold rewriting of history, and the refusal to engage with what te tiriti actually represents. It's all there. It's exhausting, but it's also telling, because when you peel it back, what you find isn't logic or reason, it's fear. Fear of change, fear of partnership, fear of losing control over a narrative that was never truly theirs to begin with. And while I can understand fear, I can't respect the way it's being used to justify this bill. The reality is this: while there are experts speaking to the nuances of te tiriti, this bill and its implications aren't complicated. Te tiriti isn't complicated. What's complicated is the Crown's inability or unwillingness to honour it. This bill doesn't need to be picked apart academically to see its flaws. It needs to be understood for what it is, a step backwards for this country and an insult to the commitments made to tangata whenua. Of the 296,501 people who signed my petition, over 154,000 are Maori, 72,000 are rangatahi, and 135,000 are tangata tiriti. These numbers matter. They represent the voices of people who care deeply about what this bill means for our country. This petition shows that we're not as divided as some would like to think. Across generations, across cultures, people are standing together to say, stop the treaty principles bill, toi tu te tiriti. What I want for this committee to consider is this. When 300 submissions come in on a single bill and nearly 300,000 signatures back a petition to stop it, what is that telling you? It's telling you that this isn't just a debate about law, it's a moment to decide what kind of nation we want to be. This bill doesn't reflect the future I'm fighting for, and it doesn't reflect the Aotearoa we deserve. Not now, not ever. It's hard to ignore the irony of being here representing a petition that has more signatures than ACT received votes to even get into Parliament. Well, Seymour repeatedly threatens to bring this bill back as many times as it takes. That's not democracy, that's ego. And it's an ego that's costing this country economically, socially, and emotionally. As a final wrap-up, I want to leave this committee and Parliament with a reminder that this bill doesn't exist in a vacuum. Every moment spent debating and redebating this bill is another moment of taxpayer money being wasted on a fight that should never have started. We hear so much from this government about economic priorities, about fiscal responsibilities, and about focusing on things that matter. Yet here we are pouring resources into a bill that does nothing to grow this country, nothing to unite us, and everything to divide us. So to this committee, to this Parliament, this bill needs to end here. Not next year, not in another government cycle, not as some political stunt to be dragged out again and again. It ends here. We are not moving, we are not backing down, and we are not going anywhere. Te tiriti isn't just history, it's our future. And no matter how many times this bill comes back, our answer will always be the same. Toi tu te tiriti.
Kia ora mai rangi, thank you for your submission and well done for the advocacy work. It's always good to see young rangatahi here. I've got a professional interest in that now, so I'd just like to thank you for being with us. Not only do you have a great surname, you've got a great sense of style, and so I'm going to hand over to Hannah to ask the first question, and then we'll go Todd and Tabitha.
Tēnā rā koe I te komiti whakahaere. Tēnā rā koe I te tuahine. I don't know how that happened. Nei rā te mihi ki a koe me o mahi nunui kua tutuki I a koe ki te kawe mai te pitihana ki konei ki te tuapapa o te wharepare mata. I nā te mahi nui ko tēnā. Tata atu I te torurau mano ngā hainatanga kua kohikohia e koe, no reira, e mihi kau atu ki a koe. Tahi noa te pātai ki a koe, ki te tutuki tēnei pire, moiho kau ana taiwa tahi he uri no ngā whakareanga kua tupu ake I roto I te kohanga, waihoki I roto I ngā kura kaipa Māori pēnei I te koutu me te whare kura o rākaumanga. Ki te tutuki tēnei pire, ka ahatia ki a koe anō, ki tō tātou nei ukaipo o mātou nei whare kura kaipapa hoki. Tēnā space.
Ngā mihi, ka whakautu pei I roto I te reo Pākehā. I think that for us, it just means we're constantly having to debate why we deserve to be in these places. And no matter how educated or how much we try and push back, they're always saying that we have to debate. And I think for us as rangatahi and those of us who have grown up in our papa kāinga, we're really accustomed to that. So this isn't anything new, but I think our biggest loss is just the waste of pūtau that could be going to support better Māori and, well, all initiatives really.
Kia ora.
Good morning. I do have probably time for one more quick question from Todd.
Hi, thank you, and thank you for making the time to submit. I just want to check, do you think that the treaty guarantees specific rights based on ancestry?
I mean, I'm not a lawyer, but yeah.
Okay, that's fine, thank you.
Probably Tamitha, if you're real quick.
Yeah, what do you think of the submissions this morning if you were watching? A lot of other generations speaking for us.
I think it's great that there's not more rangatahi and that me and Te Kanawa are kind of having to carry it all on our own. Yeah.
That's not good enough.
Thanks, Maringi. Hey, look, appreciate you being with us this morning. Hope you go well for the rest of the day and for the rest of the year.
Thank you.
Folks, that's the end of the oral submissions this morning. So